So we're going to look at 8 cases in total. We're going to spend about half the time looking at Section 423 claims, both looking at procedural issues and looking at substantive issues. Then we're going to talk about preference claims and transactions at an undervalue. And just so you can ground yourselves in these specific cases, in case you want to tune out, if there's certain matters that you know about and you don't want to know about, we're going to first talk about procedural issues in Section 423 with the cases of Manolay and Hayward, and then Lemos Bay and Church Bay Trust Co. Limited. And then we're going to talk about general 423 issues. We're going to talk about Investbank and El Husani, came out recently in May 2023, and Marina and Makalevi, which I believe also came out in June 2023. We're then going to move on to preference claims, primarily in the scope of corporate preferences. We're going to talk about the case of Kelmanson and DeVire and Gallagher, and then the case of Manolay and Coleman. And finally, we'll talk about TUVs, transactions at undervalue. We'll talk about Re City Build Limited and Re Fast Fit Station Limited. Well, moving on then to the next preference case, Manolay and Coleman. Again, we're dealing with another Manolay claim. ICC Judge Jones dealt with this matter. This case involved various payments being made by a company to its director prior to its entry into insolvency. In short, as I'm sure many of you can remember from our previous talks about preference claims, where payments are made within a certain period of time prior to the insolvency of the company, and when they are made to connected individuals of the company, it is presumed as a matter of law that the intention to prefer exists. And there's a rebuttable presumption in favor of that. So it is then the burden of proof is shifted onto the debtor or onto the defendant to prove that they were not actually preferred. And this can be obviously very difficult for defendants because they don't necessarily know the mindset of a company. That rebuttable presumption is quite difficult to get away from. The issue of Coleman, however, ultimately demonstrated a rebuttal of that presumption, which is rare and which is why it is noteworthy. The whole matter came down to ultimately the first defendant defending on the grounds that there was no intention to prefer himself as a creditor. This is an unusual case also because the defendant was a director, in fact, the director of the company who actioned the payment. So he was in a special position of actually knowing what he thought when he made the payment. That is slightly different from simply a third-party creditor trying to do the same, since they won't have the same proof or knowledge of what the intention was.